Hello, my name is Rafinata Sabila. Today I want to tell you about international law. International law has two definitions. The first one is modern approach and the second one is traditional approach. Modern approach is the body of law that regulates the activities of entities possessing the international personality, and the traditional approach is the conduct and relationship of international law. There is two divisions. The first one is public and the second one is private. Public international law is law that rules or manage things with things like state between states, country between countries, and things that matters to many people. And second one is private international law. I think if someone heard word like private, they will know private is between two person like me or my friends or something, and they deal with that problem like with two peoples or between one country and one country. International law has three sorts. The first one is treaties, the second one is custom, and the third one is general principle of law. Treaties are expressed into agreements that countries enter into voluntarily. The written agreement, the Vienna Convention on the Law of Treaties of 1969. The second one is custom. Custom are common practice into countries. The common practice that are so expect and consistent that countries can operate with the belief that the custom are required and binding. And the last is general principle of law. Principle of law are general rules of law that develop over time. So, next I will tell you about monism approach and dualism approach. In monism approach, international and municipal law as a single legal system. Regulation as a single legal system binds states and individuals. And dualism approach is not part of unified whole. In monism theory, international law can automatically enter into national court, but different from the dualism approach. I will tell you the difference between international law and national law. The international law make new rules, so the states, like all of the states have to follow the rules. But if national law, like if Indonesian make new rules, so the Singapore, United States, and Australia don't have to follow their rules, because national law is law that stay in their countries or their treaties. So it can make like Australia and United States follow their rules. So I will tell you about subject of international law. Subjects of international law is states, international organization, holy thrones, individuals, and belligerents. In order to be a subject of international law, state should have a population, government, suffrage, the recognition from the other states, and the defined territory. And the second is international organization like ASEAN, NAFTA, AFTA, APEC, OPEC, and the others organization. If they want to be a subject of international law, the international organization should have members, consist states, have a significant member groups, and have a structure. And the third one is Holy Throne. Holy Throne is like a Vatican country. They have their suffrage as a subject of international law. They cannot be attacked by any states in the time of war. And the fourth one is belligerents. Belligerents is the people that possess half of nation and real authority. Like they make rebellions into states that they want to separate themselves from their states. And the last is individual. Individual means like people or citizen in a subject of international law. Recognition is the formal acknowledgement for the status of independent state that given from the other state. There is three significance of recognition for a state. The first one is to obtain equality status, and the second is to acquire international rights. The last is to engage international relations. There is two types of recognition: recognition of a government and the recognition of a state. If recognition a government is given, it means like the state does just admit that they have a government, but they don't admit that they are a state, and different from the recognition for a state. Recognition for a state, if that given to a state or a new state, it means like the other state is admit that they have a state and they have a territory, people, and the other things. De facto recognition. De facto recognition is the government of a state is not constitutionally valid. And the second is de jure recognition. De jure recognition is the ruling power has been recognized in the entire state. One is recognition of belligerents. Recognition of belligerents is like a belligerents group that they have their own power and they can control their own country because of that rebellion that they do. And the fourth is recognition of national liberation movement. This recognition is not yet applied universally. Express recognition is like diplomatic letters or notes, telegrams, statements, or anything else. The example is like Japan recognized Korea via article on 8 September. Implicit recognition is like sending a diplomatic agent and having a talk with the head of a state. The example is like the Prime Minister of Israel. He visited Morocco on 21st of July. And the third is collective recognition. Collective recognition is doing in a multilateral conference or international treaty. The fourth or last is premature recognition. Premature recognition is recognition that given to a state although they don't have a complete structure or complete constitution. Responsibility under international law means obligation of a state associated with its international status. In responsibility under international law, there is a negligent and intentional conduct. Negligent conduct, it means that they don't know if they do that. Different from the international conduct. The international conduct, if they do that and they know what the impact from what they do, to example, they throw a garbage to the sea. If there is international conduct and they 100% know what the impact is. Next is suffrage immunity. If suffrage immunity applies, one state's judge cannot assert jurisdiction over another state in its court. Citizenship is a bond between an individual and a state that establishes reciprocal rights and duties between them. How is citizenship acquired? Citizenship acquired with 3 reasons. The first one is parentage, the second is birth, and the last is naturalization. In citizenship, there is a settlers and refugees. Settlers is a condition when a person don't have a country or the individual cannot claim the bond of citizenship with any state to protect them. And the second one is refugees. Refugees is a state may not be returned an individual to her homeland if her life or freedom will be threatened on account of her religion or political opinion.